Sorry about that. I have been talking rant for no purpose other than talking to myself, apparently. Thanks, Resist. These things happen all the time. Well, that's just funny. And Jared's let me know the same thing, probably. Oh, nope, he responded to something else in Discord. Let me go back to the start of all of this, then. Critical lawsuit over the acting attorney general by Jennifer Rubin, opinion writer from the Huffington Post. Yeah, but for posterity purposes, resist stupidity. It's Monday. I'm allowed to make these mistakes, right? Anyways, Jennifer Rubin writes, Protect Democracy, a nonpartisan legal group that has dogged President Trump on constitutional issues and violations of democratic norms for 2 years, has filed yet another suit on Monday against the Trump administration in conjunction with the Constitutional Accountability Center on behalf of the Senators Blumenthal, Whitehouse, and Hirano. Protect Democracy is challenging the appointment of Acting Attorney General Matthew Whitaker. In a news release, the group explains. The Constitution Appointment Clause requires that the Senate confirm high-level federal government officials, including the Attorney General, before they exercise the duties of their office. The framers included this requirement to ensure that senior administration officials receive scrutiny by the American people's representatives in Congress. The Appointment Clause is also meant to prevent the president, in the words of Alexander Hamilton in Federalist 76, from appointing officers with, need to learn to breathe, with, quote, no other merit than that of possessing necessary insignificance and plenty to render them obsequious instruments of his pleasure, end quote. I.e., the president can't owe you a favor and then just appoint you. It's got to go through the Senate. And under normal circumstances, I would agree. President Trump's violation of the Constitutional Appointment Clause unilaterally prevents members of the Senate from voting on whether or not to consent to Matthew Whitaker serving as principal officer, leaves senators no choice but to seek a remedy through the courts. Senate Minority Leader Chuck Schumer issued a statement Monday, quote, I commend Senators Blumenthal, Hirano, and Whitehouse for bringing this important lawsuit and shining a bright light on the president's unconstitutional appointment of Matthew Whitaker as acting attorney general. Putting aside Mr. Whitaker's many conflicts of interest and history of hostile comments towards the special counsel's investigation, his appointment as acting AG is in direct violation of the Constitution's appointment clause and should concern every American, regardless of party affiliation, who cares about the rule of law and justice in our country. And I'm going to go back to this site from Justsecurity.org, a quick primer on the legality of appointing Matthew Whitaker as, quote, acting, end quote, attorney general, and Whitaker's power to influence the Russian investigation. And as you can read here, Justice Sessions resigned yesterday, meaning November 7th, as this was posted by Marty Letterman on November 8th. At the president's request, the president promptly tweeted, we are pleased to announce that Matthew G. Whitaker, chief of staff to the Attorney General of Sessions at the Department of Justice, will become our new acting Attorney General. We? Who's we? A somewhat odd location, especially in light of Trump's claim that current litigation that he uses his Twitter account only in his personal, not his official capacity. Funny. The announcements raise a bunch of questions, primarily about the legality and length of Whitaker's appointment, and about what authority Whitaker will have in respect to the Russia investigation of Special Counsel Robert Mueller and other investigations. Here's a quick effort to answer some of those questions based largely on earlier posts in which I have discussed issues in somewhat greater detail. I'll update this post when further information comes to light. And the first question is pretty self-explanatory. Who's currently performing the functions of the Attorney General? And under the normal rules of succession, it would be Rod Rosenstein. However, the president announced, excuse me. However, the president has announced that Matthew Whitaker would do that, and the basis of this Succession Act is from the time the DOJ was established in 1870 until 1953. The statute provided that the Solicitor General would be acting attorney in case of absence or disability of the Attorney General or vacancy in the office. In 1953, Congress enacted a new law now codified as 28 U.S. Code subsection 508, which transfers that interim authority to the Deputy Attorney General, or DAG. Subsection A of the statute provides that, quote, in the case of vacancy in the office of the Attorney General, or in the absence or disability of the Attorney General, the Deputy Attorney General may exercise all duties of that office, i.e., the office of the Attorney General. Now, the question that really gets people in rile, especially on the Democrats and the far left here, is what's the authority for Trump to direct Whitaker instead of Rosenstein to perform as the AG's functions? President Trump, however, has said that he will soon, if he hasn't done so already, direct Matthew Whitaker to perform as AG's functions and duties, thereby displacing Rosenstein. As soon as Trump formally directs Whitaker to do so, yesterday afternoon's tweet presumably didn't do the trick, Whitaker will presumably take over in the performance of all those functions of duty. Update as of Thursday afternoon, acting Attorney General according to the DOJ. And just to be clear, it's a very big deal because the Attorney General is a statutory assigned to perform or delegate to others almost all of the functions of the duties of the Department of Justice. See 28 U.S. Code 509. Okay. Oh, by the way, I'm also streaming on stream.me, and I have totally neglected to see if anybody's in chat. Let's see here. Let's go to my stream. I have totally forgot about you guys over there. I'm so sorry about it. All right, so back to where I was. All right. So, what's Trump's authority for superseding the AG succession statute? He's undoubtedly invoking the Vacancies Reform Act of 1998, the VRA, which provides in 5 U.S. Code subsection 3345 paragraph 3, that the president may direct an officer or an employee of an executive agency to perform the functions and duties of a vacant office, provided that that officer or employee has served at least 90 days during the year before the vacancy in a position for which the pay is at least the level of GS 15, a criterion that Matthew Whitaker does satisfy. Now I'm going to pull up that act here. And here's the acting officer of the Title 5, Part 3, Subpart B, Chapter 33, Subchapter 3, Subsection 3345. And if an officer of an executive agency, including the executive office of the president, and other than the government accountability officers, whose appointment to the office is required to be made by the president, by and with the advice and consent of the Senate, dies, resigns, or otherwise is unable to perform functions of the duty of office, and it goes through all of the succession rules. However, if you see, notwithstanding paragraph 1, the president, and only the president, may direct an officer or employee of such executive agency to fill the office vacancy temporarily and in an acting capacity, and to the time limits of subsection 3346. So let's change this over to 6. Cut. Whatever. Except in cases of a vacancy caused by sickness, the person serving as an acting officer as described under section 3345 may serve in the office for no longer than 210 days beginning the date of the vacancy occurs, or, subject to subsection B just below here, once a first or second nomination for the office is submitted to the Senate, and from the date that such a nomination for that period, for the period that the nomination is pending by the Senate, or if a first nomination for the office is rejected by the Senate, withdrawn or returned to the President by the Senate, the person may continue to serve as an acting officer for no more than 210 days after that date of such rejection, withdrawal, or return. Notwithstanding, paragraph 1, if a second nomination for the office is submitted to the Senate after the rejection, withdrawal, return of the first nomination, the person serving as an acting officer may continue to serve until the second nomination is confirmed or for no more than 200 days after the second nomination is rejected and withdrawn. If the vacancy occurs during an adjournment of the Congress, sending, the 200-day period will, under subsection A, shall begin at the date the Senate first reconvenes. So, in layman's terms, the way that I read that is that the president does have the right to do this based on the VRA, and under section 3345 and 3346, Whitaker is capable of doing that. The question is the legality. Is it truly the president's decision and ability to do that? And I'm okay with actually a lawsuit over this. I'm quite all right with that. All right. The Justice Department's formal view is that the VRA provides the president with an alternative authority in addition to the AG Succession Act to designate who shall perform the AG's functions and duties during a vacancy in the office. Thus, for example, when AG Alberto Gonzales resigned in 2007, President Bush named the Assistant Attorney General for the Civil Division, Peter Kessler, to be the acting Attorney General, when the AG succession order in effect at that time, issued pursuant to the AG Succession Act, would have assigned those functions to the Solicitor General, then Paul Clement. As far as I know, however, the appointment of Whitaker would be the first time in U.S. history that the President has designated an acting Attorney General. The President has designated as an acting Attorney General someone who was not then serving in an office to which he or she was appointed by and with the advice and consent of the Senate. It would be the first time since 1869, i.e. since Congress enacted a specific AG Succession Act, that the acting AG would be anyone other than a sitting Senate-confirmed DOJ officer. In 1868, the Secretary of the Interior, Orville Browning, served as acting AG for a few weeks while his own ultimately unsuccessful nomination to the AG was pending in the Senate. And in 1848, President Polk named Secretary of the Navy John Mason to serve as acting AG for weeks before Isaac Townsend was confirmed. Mason had himself been the confirmed AG just 2 years earlier. So, I agree. Resist this. This is a that this will put it to the test. Honestly, I think that the lawsuit is perfectly viable, and I'm not actually saying that this op-ed is wrong. I'm just saying that I think as I go through it, you'll see that what I'm really going to be saying is that she's dismissing this this part of the argument that people have made. And I think that's what a lot of people might be doing. Question 3, is Trump appointment of Whitaker as acting AG legal? I'm just going to go with this short little paragraph here. Perhaps, but perhaps not. There are two possible bases for challenging the legality of the Whitaker appointment. Now we're going to go back to the op-ed down here. The litigants' argument is simple and persuasive. President Trump has violated one of the core checks and balances contained in the U.S. Constitution by violating the advice and consent process in the Constitution, a key check on executive power. I do not deny that. Especially in the case where the president has consistently attempted to micromanage the Justice Department, e.g., calling on the prosecution of his opponents, pressuring the AG to unrecuse himself. I don't think it was quote unquote pressure. He was upset that he recused himself. If you try to read into Donald Trump's words too much, you're going to find any meaning that you want. And I don't care which president it is, Obama, Clinton, Carter, Reagan, Bush's, both of them. If you're an opponent to the person, you're just not going to care what they have to say and what they do. And therefore, everything is wrong. So, let's not do it. It's essentially for the AG to be seen as someone who is not simply a rubber stamp for his political patron. Based on the reaction from both from Republicans and Democrats, Whitaker very likely would not have been confirmed by the Senate. That's very much true. That's what I have read. While it is true Whitaker, given his public statements about the special counsel investigation and his role in advising Sam Clovis, should not be in charge of that inquiry, that strictly speaking is a recusal matter. What is at issue is the lawsuit. In the lawsuit is whether the president can appoint Whitaker without the Senate's consent. If Trump can, it's not clear why future presidents would bother with Senate confirmation for controversial appointments. There is a legitimate issue of standing, whether the senators are the ones to bring the lawsuit. However, in this case, they seem to have a powerful rationale why the judicial branch needs to weigh in. The complaint states that these three senators were denied the right to vote, guaranteed to them by the Appointment Clause. The plaintiffs note that Congress passed a statute prescribing the order of succession in the event of a vacancy, the DOJ succession statute, which we've discussed. The Federal Vacancies Reform Act, they argue, that allows the president to fill an opening under some circumstances does not override the DOJ succession statute and does not allow someone such as Whitaker, who's never been confirmed by the Senate to step into the role of an acting attorney general. That is something you would actually have to ask the president himself. We won't know his real reason until he actually discloses it to us. However, speculation on my part, which I hate doing, but if I were to speculate, is not so much that he is trying to have Whitaker dismantle the Mueller investigation or put a stop to it or anything like that. I have a feeling it is he's trying to just stir up the pot. Basically, he's trolling the Senate because he's found a loophole that technically, legally gives him the opportunity to do this. And since the Senate and the House of Representatives, since the midterms, has been altered a bit, he probably feels it's time to troll them a bit. I mean, I honestly don't see any other reason why. That seems legitimate to me. I mean, he very well could be trying to dismantle the Mueller investigation, and I could be 100% wrong. I totally could be. If it turns out I am, I will gladly accept that. But I just don't see it. I just don't see it as doing it. The senators seek declaratory relief that Whitaker was appointed to perform the duties of a principal officer of the United States, reporting to the president, and therefore that he is in violation of the Appointments Clause. They asked Whitaker to be enjoined from performing the duties of acting Attorney General. The question is not why these three senators acted in defense of the Senate's prerogatives, but why the Republicans refused to. Under Senate Majority Leader Mitch McConnell, the Senate is no longer the world's greatest deliberative body. Indeed, it does not deliberate at all. McConnell refuses to consider legislation to protect the special counsel and refuses to confront the president on his unconstitutional usurpation of the Senate's powers. Yet, it's yet another powerful example of why Republicans are not fit to hold power. If they cannot uphold their oaths and defend their explicit role under the Constitution, they have no business being there. And since this is an op-ed, I am not going to complain about the bias in that last paragraph because, again, it's an op-ed. It's her opinion, and she's entitled to it, and I don't have to agree with it. But I do agree with it to an extent because Mitch McConnell is being an idiot by not allowing them to deliberate. However, back over to the other article. First, OLC. Sorry. Did we cover OLC up here before and I just didn't see it? Sometimes when I hop back and forth, I forget where I see things. Apparently I didn't, but whatever. First, OLC might be simply wrong in its conclusion that the VRA is an alternative authority that the president may use in lieu of the AG Succession Act to fulfill a vacancy in the office of the Attorney General. John Bice has suggested as much, i.e. that Congress's office-specific instructions that the AG succession statute about what should happen when the AG office is vacant should supersede the more general provisions in the VRA. Resist stupidity, in my opinion, by looking at the evidence. The acting AG's attitude towards the probe and his miraculous appointment does give reason to be suspicious of the president trying to hide something. I totally agree with you. However, Donald Trump is not a stupid man. And I'm no way trying to defend Trump in this. Because again, I really want to see what turns out about this because I don't agree with the Whitaker appointment at all. However, knowing that there is precedent to allow it, i.e. the legal side of it, is what appears to be in the VRA, is, by all honesty, what we have to go by until the Supreme Court or a district court rules on it, and then the Supreme Court, so on and so forth. But it is what it is. I haven't thoroughly researched or considered the question, so I don't know. I don't know. I think that's supposed to be so I don't now have a clear view about whether Bias is right. I have some tentative doubts, however, in light of the particular circumstances surrounding the enactment of the 1998 law. To be sure, and as OLC noted in footnote 1 of its 2007 opinion, all right, so what is the OLC? I feel like I should know that, so. Office of Legal Counsel, that's what it is. Having one of those days. Simple acronyms are beyond me. Alright, so in as the OLC noted in footnote 1 of its 2007 opinion, the Vacancies Act that preceded the 1998 VRA expressly excludes its application to the Office of Attorney General, and the version of the VRA that the Senate originally approved in 1998 would have done the same. Thus, the Senate report that stated that, quote, with respect to vacancy of the Office of the Attorney General, 28 U.S. Code subsection 508 will remain applicable. That section ensures that the Senate confirmation Justice Department officials will be the only persons eligible to serve as acting Attorney General, end quote. I do find that interesting. Congress, however, for reasons that the legislative history does not explain, far as I know, did not include the relevant 508 exclusivity provision in the final enacted version of the 1998 VRA. I don't mean to suggest that this settles the question, but it's a reason to be cautious about assuming that the AG Succession Act remained the exclusive means for the president to designate acting AGs after 1998. Yes, it will be nice to see what unfolds in the end. I agree. Second, there's a possible constitutional problem in using the VRA to replace a principal officer, such as the Attorney General, when someone who hasn't been confirmed by the Senate for that office, or even for a related office within the DOJ. In a recent concurring opinion, Justice Clarence Thomas argued, do we already have? We do. We already have some sort of the NRLB versus Southwest Ambulance. Oh, I know who they are. That's not a good thing. Argue that such a temporary appointment would violate the Appointments Clause of Article 2 of the Constitution, Article 2, Section 2, Clause 2, which provides that such principal officers must be appointed by the President by and with the advice and consent of the Senate. Apparently he's edited these two out. That's fine. There's probably something to Thomas's arguments, but it's complicated. Most significantly is the 1898 decision of United States versus Eaton. The Supreme Court held that a temporary appointment to a principal office was constitutional. Indeed, that if the assignment merely involves the performance of duties of the superior for a limited time and under special and temporary conditions, the office is inferior, even though during the period the officer is not supervised and removable by a principal officer. A contrary holding, the court explained, would render void any and every delegation of the power to an inferior to perform, under any circumstances or exigency, to the duties of a superior officer and discharge the administrative duties would be seriously hindered. This would appear to be inconsistent with what we've come to think about as the Edmund test for distinguishing inferior from principal offices, which ordinarily requires at a minimum supervision by an officer other than the president. But in Edmund itself, Justice Scalia favorably cited Eaton. Quote, among the offices that we have found to be inferior are that of a vice consul charged temporarily with duties of the consul, end quote, in support of the broader acknowledgement that, quote, our cases have not set forth an exclusive criterion for distinguishing between principal and inferior officers for appointments clause purposes. See also pages 123 and 124 of this 2000 Office of Legal Counsel opinion, relying on Eaton. wow, this goes on forever. Anyways, I was just trying to make this brief and simple and just kind of provide some light onto why somebody or why people would want to have the um, why people think that it's okay for him to have it, and why people don't think it's okay for him to have appointed Whitaker. I'm of the opinion that right now, based on what I have read, what I have seen, is that he technically does have that ability. I'm glad to hear that this lawsuit is being brought forward because I do think it does make the Senate's appointment or advice and consent and the appointments clause moot to an extent. However, I do also understand that there is a time limit for these temporary appointments, and that is basically 210 days based upon all this information. So, the way the Senate could get around this is to wait for 210 days. And if he hasn't made an appointment there, then he would have to appoint somebody or Whitaker is out. Now, 210 days gives Whitaker a long time to make some broad changes, including messing with the Mueller investigation, which I don't think will happen, but I understand why people think that does, why they think it will. Let's see here. All right, so let's see, 200 timeanddate.com. You were awesome, by the way. So this would have been 11/7/2018. Oh, I didn't want to do that. Add days. That's what I want to do. $210 days. So 210 days would be June 5th. So they have until the president has until June 5th, 2019 to appoint somebody or appoint Whitaker, to which point he would be accessing to the he would be able to do whatever he wants. Now, as his chief of staff to Jeff Sessions, I would assume that he had to have had some sort of vetting and security clearance information passed on. So, again, I just think that we as a society we allow these things to polarize us. We allow them to make us seem extreme and combative against our political opponents far beyond what we really need them to be. So, let's take a moment and see what's going on with the whole process. Let's take a moment to see how these things are going to go in the courts. That's really what we need to do. I hope that you guys will take that time, and I will be posting all these links that I shared into the messages or into the descriptions of my streams here. So when I'm streaming my political stuff, you can catch me here on YouTube. You can also catch me on stream.me. If I am gaming on my computer, you'll be able to catch me on YouTube, stream.me, and Twitch all at once. So, hope you guys enjoyed this. I hope that you guys will post questions in the comments section, please. I look forward to having discussions and debates. I'm probably going to pull this one down and edit it because I was an idiot. Thank you, Resist, for pointing that out. So, but it's all good. We'll figure it out. Hope you guys have a wonderful week. Enjoy your Thanksgiving for those of you that are in the U.S. Enjoy football on Thursday. Eat lots of turkey, pie, green bean casserole, ham, whatever you guys do. Enjoy it with your family, your friends, share your traditions. Don't look at this as some might call it the the harbinger of the death of the Native Americans because of how our ancestors treated them, etc., etc., etc. Just look at it what it is and what it was originally supposed to be with the Pilgrims and the Native Americans. A communal feast. So, have a good night. Take care, everybody.